Well, welcome to the TuckerAllen Virtual Town Hall as we continue to bring this series to you with some of the latest information on things that you need to know about estate planning. And today is no different. And more importantly, we're going to be talking about the 5 worst things you can do, the mistakes that you may make when you're talking about estate planning. That's always good. So get a pen and a paper out so you can take these notes. It's important. We're going to be moving very quickly so we can leave enough time for you to ask questions live. You want to make sure to submit those via the Q&A section or the chat box, either one. And we'll spend some time in the second half of our virtual town hall addressing those questions. So if you just want to put your name and where you are, where you're from, the state, and we'll go ahead and try to answer those for you. But as always, I start this again. I'm Scott Trout. I'll be your moderator. This is not to be taken as a substitute for meeting with an attorney or establishing an attorney-client relationship. Obviously, there's so much that goes into estate planning that is so unique to your individual circumstances. It is highly encouraged to find an attorney that practices exclusively in estate planning like our panel today. And so I would encourage you to find out more about TuckerAllen at TuckerAllen.com. If you don't want to submit any questions via the Q&A or the chat section, you can submit those on TuckerAllen.com/questions. And we'll get to those, especially tuning in on Fridays. If you have 15 minutes, you can tune in at Facebook and you can see TuckerAllen Live, where we go ahead at 1 o'clock. We address some of your questions and a really quick topic for the day. This Friday is no different. It's going to be a good one. We're going to talk about funding and what do you do and some of the things you need to look out for in funding your trust. So very important, critical component. I know today we're going to talk about funding as well. So let's go ahead and talk to our panelists to introduce them from St. Charles, Missy Manning. Welcome.
I practice out of our St. Charles and St. Louis offices, and I'm licensed in the state of Missouri.
Thanks, Missy. Let's go to Teresa in our Edwardsville, Illinois office. Teresa Yao, welcome.
Thanks for having me, Scott. I work out of our Kirkwood and Edwardsville offices, and I'm licensed in Missouri and Illinois.
Thanks, Teresa. And rounding out in our Kansas City Metropolitan office is Kevin Mason. Welcome, Kevin.
Hi, Scott. Thank you so much for having me. I work out of the KC office, like you said, and I'm barred in Missouri.
Thanks, Kevin. So check out TuckerAllen.com. A lot of information, including some of the fixed fees that you'll see. So kind of a very transparent process. So you know if you can schedule an appointment as well. You can give them a call at 866-335-3375 as well. So also make sure for those just joining us, submit your questions via the Q&A section or the chat section. We'll get to those live and get you some answers. We have some questions already coming in that we'll address in our second half of today's virtual town hall. And don't forget to check out TuckerAllen Live on Facebook coming up Friday and every Friday at the same time, 15 minutes. We'll address some very, very quick topics. So we're going to get started with our 5 worst estate planning errors that people make. I know it's important, but first let's go to a quick break and we'll come right back.
I wasn't really avoiding it, but I'm pretty good at procrastinating. I needed a trust. When I found TuckerAllen, all our questions were answered, all of our fears allayed.
You want your wishes in place, so there's no guessing, no stress on the children.
Basically, they talk about what you need, what's important to you. It was more conversational, really very simple.
Welcome back. You know, as we talked about in the break there, it is really simple. We want to make it simple, and it's one of the reasons we want to talk today about the 5 most common errors that are made in estate planning. There are plenty of them. I can tell you that if I go through these, I'm going to say, yep, made that, but it's not too late. You want to schedule an appointment with someone who practices exclusively in estate planning, and we'll make it easy. TuckerAllen does. So let's talk about that. Teresa, one of the things I know we've talked about in previous virtual town halls, as well as some TuckerAllen Live segments, about proper planning and sharing information. Like, who do you share your information about your estate plan with? And that really is probably not necessarily in order as being the most common mistake, but you would agree, obviously, not sharing information about your estate plan with those who need to know most would be a common error, right?
Yes, absolutely. So yes, you created your estate plan, you have all these documents, it's really beautiful, but if you don't tell the people who are actually going to use it, then what's the point, right? They're just documents sitting in a really beautiful safe, and then it's not actually working for you. So I think that's a common problem. I think people create an estate plan that they're like, oh, this is my plan for all my valuables, so I have to keep it really safe and keep it really private. And I think I admire that instinct. I think it's a good instinct to have, but I think to counter that, you also have to feel comfortable with the people that you set as your trustees, with your personal representatives in your will, certainly your powers of attorney in your healthcare and financial powers of attorney. These are agents that are acting for you. So you want to make sure that they know. So preferably before signing, you talk to all of them so that they know that you've appointed them in these positions, because they're positions of responsibility. They have duties that they'll have to carry out.
It's one thing, as we talk about routinely, and more importantly, during the pandemic. We've been going since February at least. And we think about the one item about death. We don't want to think about it. We don't want to think about incapacity. We don't want to think about being in the hospital. We've talked a lot about durable powers of attorney for healthcare, and what happens when you're in the hospital. What happens when you can't make your own decisions? What happens when you need someone to handle your finances? And so, I think that talking about this mistake, and maybe more particularly, let's talk about those. I know you mentioned very quickly. Maybe list out who it is that you really should be thinking about, because it's very easy. And I can tell you from experience you feel accomplished. You get your plan done and you're like, whew, check, done. And then you, as you suggest, you put it in the safe and it just gathers dust, but you got to take that next step. One of the, I guess that's pretty clearly to me now, as I listened to you talk about it, was I need to start telling people about my estate plan and providing them with copies. So let's maybe talk about the durable powers of attorney. Who should be getting those? Who really is, the mistake where you don't tell them about that?
Yeah, so for the powers of attorney right now, we think about the financial one and the healthcare one. And I guess because of the pandemic, the healthcare one, it really is important. So after you create your estate plan, I always tell my clients, next time you go to your doctor's office, or whenever you feel comfortable, or if you have a good contact with the doctor's office, you don't need to make an appointment. Just tell them you created a power of attorney. What's a good way for you to share that information with them? Or if you are going to the doctor's office for whatever reason, bring them with you and ask your doctor to scan it into your electronic medical records. Or if there are paper copy plays, ask them to make a copy and keep it with your records, so that in the future, if something should happen, all your different healthcare providers should have a version of your healthcare power of attorney, so that they know who to contact if something were to happen. Likewise, for the financial power of attorney, that one, you can also be proactive. You can go ahead after our signing time with TuckerAllen. You can go to your bank and say, hey, I created a financial power of attorney. Can you just put this on record just in case if something happens and I have an agent coming, they can act on my behalf.
Yeah, it's so important. If anyone listening, watching, obviously may have had a friend, a loved one, unexpectedly go to the hospital, and they may ask, do you have a power of attorney? Do you have a healthcare directive? And your doctor, you just avoid that. They know it. It's on file. It's already listed. I think that's really good advice, especially when you're appointing trustees and those individuals to act on your behalf. I know I've talked about this in previous town halls, and that is, I had conversations with each one who my wife and I appointed as healthcare, as finance. We wanted them to know, not to be surprised in the event that something happens, that, wow, I had no idea I was appointed as the person in charge. And I think that just helps ease their mind if that event happens, right? I mean, that they know what to do and what to expect, and they know where to go.
Yeah, so I kind of think about telling the people or entities that need to know at two different points. One is before you execute these documents. Make sure all the people that you're naming actually accept that responsibility, understand that what you're putting on them. And because sometimes you might think, oh, this person, they're totally fine. And then when you have a conversation with them, they might be like, whoa, I don't want to be put in that position to make the really hard decision. I think maybe my other sibling would be better suited. So definitely have those conversations before signing the documents. And then after signing the documents, that's when you talk to your doctors, the banks.
Yeah, agreed. Even if you're going to name a custodian for your minor kids, probably a good idea to check with your, whoever you're naming, saying, are you comfortable taking on another 5 kids in your house if something were to happen?
It sounds kind of silly to even have to say that, but you'd be surprised that it's important to have those conversations.
It is. I think that maybe that's the one thing I've talked about COVID and about how it should be changing the way we think and the way we behave in terms of being proactive. And it's not morbid. It's not something that anticipating death. It's brought everything maybe a little more clarity and urgency. And we've been talking about this for weeks, 37 weeks now. And that is, if you don't do something now, when are you going to do it? And that's so important to take action, to protect yourself, to protect the ones you care about, and to protect your stuff, and to make sure you do something with it. So I guess, Teresa, if you don't have these conversations, if you don't share the information, what are the consequences really? Kind of what are the negatives that kind of led us to really putting this as to an error or mistake that people make?
I mean, let's just take the powers of attorney, for example. If you don't share this information with your doctor, if suddenly you're incapacitated and they just never knew that you created a healthcare power of attorney, then they don't have that to look to. And then so they're just going to default to whatever family member happens to be their friend that happens to be there that brought you in the hospital to try to make a decision for you if it's time urgent and they need to make that decision on the spot. So I think the consequence is that you're kind of leaving it to the mercy of whatever circumstance arises down the road.
Mm-hmm. Which brings up the point I know we've done. I love the idea. We've talked about the GO package, and we're going to talk about that in a minute again. I love it. I think it's a great idea. And if you can remember it, everyone watching right now, if you don't know what a GO package is, you need to call TuckerAllen, find out, because you need it. But the point is that when you have these conversations and you talked about keeping your documents in a safe place, just as important to tell them where it is and how to get to it.
Yeah, and I think we talked about this in earlier Facebook Live events. I think the golden rule is safe but accessible. Mm-hmm. Obviously, you want to keep all this information about you and your belongings safe, but your trustees, the people that you trust with these roles in your documents, they should probably know where you keep your GO package and where you have your documents, so that if something were to happen to you, they know exactly where to go, for example, or the code to the safe, so that they can access those documents and start acting on your behalf.
Mm-hmm. And if they haven't provided, I don't know if you talked about this, but go to your healthcare provider, present them with a copy and have them scan it in, put it in your record, right?
Mm-hmm. Yeah, exactly. You want them to put in your electronic medical record, but if they don't use EMR, I think some places still use paper copies. Ask them to make a copy. And I think we all like to think that the healthcare system is really integrated, but it's not. So just to be safe, if you see different doctors, different specialists, the next time you see each doctor, just bring in those documents and ask them to put it in together with your medical
Mm-hmm.
records.
It is interesting is if you go to different doctors and they don't ask, hey, do you have a healthcare directive? They don't, I can tell you that I've not been asked whether I have it, because if they did, I would think, oh gosh, I forgot, I got to provide it. So it really is important. I think that's why it's a really good point to make about mistakes people make, is making sure that you're providing that document, providing it to the right people and sharing that information. So good stuff. So Missy, I want to talk to you about a mistake or an error number 2. Again, not in order, but that choosing the right person, choosing the right personal representative, choosing the right agent. What do you mean by that? How is that a mistake or kind of an error that someone doesn't really consider?
Okay, so for the purposes of this discussion, we're just going to call them all agents, because there's a whole bunch of different fancy names for them depending upon what document it's underneath. So all of your personal representatives, your trustees, your agents under a power of attorney, we're just going to call them agents. And you have to choose the right person for those roles. It's super important. These people have a ton of power over your finances and your person if something happens to you. So we want to make certain that they are absolutely 100% trustworthy. That's probably the biggest thing above everything else, is that they have to be trustworthy with you and your finances and your children too. So we want someone that's fair and reliable and honest. Ask yourself, do you trust them to do this for you right now? And if the answer is no, then they should not be put down as an agent on any of your documents.
You know, let me ask you real quickly as you're thinking through it, because I think it's, I've said this before, I'm a client of TuckerAllen, and it was really interesting as I thought through the process. We have 5 kids. We were trying to decide, and we trusted all of them, but really about who was the right person for the right thing. And each of, it could be friends, it could be family, it could be your children, right? And each of them have unique traits. And I think making sure that you go through those things and making sure you're choosing the right thing for the right person for the right reasons. And it could be a number of different things. It could be, for example, we wanted our daughter, who's a nurse, to make medical decisions because we felt she was, one, equipped, and two, could handle it. We did, I've seen people who've been designated as the healthcare directive, and they just weren't ready for it mentally. They didn't feel comfortable with it. And I think that's right. And not necessarily trustworthiness, but I think organization, and make sure that they're in the same city. Is that important, especially with healthcare directive?
Yeah, so organization is another big one. These are very complicated duties, and you want to have someone that will answer the phone and get things done immediately. And then the other one is local. So local helps, having someone in the area. In this day and age with technology, it's not necessary. So if you don't have a good fit here that's local, it's not the end of the world, but it is very useful to have someone that can go up to the hospital and talk to the doctors, or go up to your local bank and talk to them there if there's a problem. Another one is if they're going to be handling cleaning out your house or something, it's much harder if they're going to have to fly in for successive weekends to clean out your house. It's time consuming and takes a lot of effort, and that's a lot of money and flights and hotels.
Yeah, you think about the trustworthy part. I mean, you want to make sure not necessarily they have the same values, but they understand your wishes and you believe that they'll follow them, right? Even if there's any vagueness in there. I mean, certainly you're not going to pick your enemy and to make, well, yeah, let's go ahead and pull the plug, right? And they're not going to make the decisions that are in the right interest for you. I think that's very important because, and we don't like to think about these things because, I mean, look, I'm young, I'm healthy, but it is important to make sure you pick the right people. That does give you that sense of ease and comfort, knowing that once you've taken that huge step of preparing your estate plan, your medical directives, your financial, not only you, but everyone around you is taken care of as a result. So it's a really good point to think about those things critically. And I think as you wrote those down or mentioned them, people should write them down. Trustworthiness, organized, local, and maybe even a good financial sense for those that have financial interests. You got to make sure. But maybe the question is, as we think about what you're looking for, what should you look for that a reason not to choose someone? Maybe that's more important too.
So a very common one we hear from a lot of our clients is they're going to choose one of their children because they're the oldest. So either the oldest child in general or the oldest daughter is typically one that gets nominated. And that is a terrible reason why to choose someone. This is not an order of precedence. It is not an honor. This is a heavy burden and it needs to be done right. So simply because someone was born first doesn't make them the best person for the job.
I think that's huge. I can speak from, experience that we have 5 kids and we chose our oldest for something unrelated. People may look at it, and I think he would look at it as, well, the financial power of attorney, that's the most important, but that's not his strength. So you make him a trustee or personal representative, something, that has its own unique nature. But I think you do. I think that you have to make sure you're picking the right kid or for the right reason, not just age and birth order, because they all are different. And I think that's huge. So is it automatic that you should just choose family members?
No, actually, we have lots of people who don't have great, reliable family members. It's not uncommon. Lots of people end up choosing friends. And then if you don't have any friends that you would really trust to make decisions, then there are always corporate trustees and corporate agents that can serve for you. These people are professionals that you hire that will handle all of the affairs for you in a very professional and detailed manner. There's usually a fee involved, but if you don't have someone that's a good choice, these people are bonded and insured and are very reliable choices for someone to fall back on.
Mm-hmm. And especially if you have multiple kids, one of the things, obviously, and it's something we didn't make a provision of responsibility for all 5 of our kids. Is that something also to watch out for? It's okay to do that and something you shouldn't feel compelled to do?
Correct. So sometimes people say, we're going to have this child be first on this one, and then this next child for the next one. Having them alternate like that might be fair in your mind so that everyone is doing a particular duty. However, that doesn't mean that they're right for that duty. Sometimes it might be better if the same child does all of the things, if that's the best child.
Yeah. So as you think through the mistakes, what are the potential problems as you're going through those and identifying agents, as you suggest, that you can do to avoid?
So the number one mistake we typically see is they name multiple agents serving together. So it's not just child one, and if child one can't serve, then child two will step in and serve. It's child one, two, and three, maybe even four, all serving together, having to make one decision at the same time. And that is never a good idea. It leads to inaction where they all have to have their own input. They've all got to agree on something, and it's just not going to happen in a quick and timely manner. We could have duplication of effort where one child sends off this check and then the other child thinks that it's not been done and the check gets sent off twice. Or, well, another one we had was the mortgage was never paid, so the house went into foreclosure because they all thought the other one was doing it.
Wow. So, I mean, there's got to be conflict, especially if you're naming siblings that may or may not have the same thought process. Same, you know, I know it's funny. My kids say, well, Dad, you're going into a nursing home as soon as you can. As soon as I can put you there, you're going into one. And it's kind of the running joke. But then one of my others is like, I'm never putting him in a nursing home. I mean, has that become an issue that you can avoid?
Yes. So obviously you would want to choose the child that goes most with your feelings. So if you don't want to be in the nursing home until you absolutely have to, then probably don't choose the child that says they're going to throw you in there as soon as possible.
Yeah, it is funny. It's a running joke. And my wife says, well, I'm just going to escape from the nursing home, so it doesn't matter. And good luck catching me. So, but it is important. Again, it emphasizes where, sitting people down, and it shouldn't be. If anything that is a positive out of COVID, and that is we have good, direct, honest, transparent conversations with the people that are most important to us about kind of what we want in the future. And if it happens, great, but then we're all equipped. I think that's the whole point of identifying the common errors people make. And this is one of them, is feeling satisfied by just taking the step of getting your plan done. There are a lot of people watching that haven't taken that step, and I can't tell you how important it is to do it now and how affordable it is to just take those things. It's just time. It's really important. So thanks, Missy. Kevin, I want to talk about something now. There's people watching that have taken the step of actually getting their plan in order, but one of the mistakes and errors they make is not modifying or changing it based upon either life changes or law, right? That's important.
Yes, absolutely. So both of those things that you just said, the law changes sometimes, and then so do family events, personal events, things change.
Yeah, I think it's huge. Life changes. Gosh, I mean, I was young when we first did our estate plan. Before we had one child, and 20 years later, I've got 5 kids, and obviously that's a huge life change, and you have to be really thinking about what's happened. A lot changes over the course of time. You could be, middle-aged and you make it, and life changes, but marriage is one of those changes, isn't it?
Yeah, so marriage is absolutely one of the changes, and kind of a common problem that we see sometimes is people, they'll be married and they just assume that upon their death, their spouse is going to receive their assets without having a will or a trust in place, which that just isn't the case. It can lead to some very sticky situations. Here in Missouri, the spouse of the person who has passed away without a will or a trust, the spouse is going to get the first $20,000 in assets, and then the rest of those assets, if there are children, are going to be split between the spouse and the children, which can lead to some very strange situations where a minor child could have, own part of the house with their mom.
Yeah. I mean, it's huge. I mean, keeping in mind as we're talking about this, not updating your plan, if you have questions, don't forget, submit them in the Q&A or the chat box. We have some coming in now. Again, Q&A or the chat box. We'll get to those here shortly in the second half. But as we think about, and I mentioned earlier, from my example where we had kids later, you could be, later in life, and isn't one of those life changes either new kids, births, or adoption, or grandkids, right?
Sure, absolutely. If you're later in life and have a child, or if you've already had children and they adopt a child or they have a grandchild now, that might be someone that you would want to plan for with your estate plan, be that a will or a trust. And instead of just leaving it the way it is, you might want to go back and put something in there for them.
Yeah. And then, the one that affects 51% of the population, that is divorce. And that's something, obviously, it's stressful enough to go through that. And then you just don't even think about changing your estate plan, right? And that's a huge one.
Sure. So the two big ones here so far that we've talked about are going to be marriage and divorce. So divorce is another one where people, they get divorced and then they assume that, okay, now I'm divorced. This divorce has totally taken them out of my estate plan just by the action of divorcing them. And although that could be the case in some circumstances, such as maybe a trust that we've written here at TuckerAllen, it would say, okay, if you get divorced, then we're going to pretend that this person predeceased you for anything that you have mentioned them in the trust. But in other facets of your estate plan, it's not going to be that way. So if there's still POA, if they're still your POA, or if they're still POD on a bank account or TOD for a vehicle that you own, that they're still going to be there on those even after the divorce. So that's something you need to go back and change.
You mentioned, a POD, or, a change of assets. We all acquire things over life, over time, inheritance or purchases, acquisitions somehow. That's a big one, right?
Absolutely. So sometimes you make a large purchase, maybe you buy your first home. That would be a great time to come in and work on your estate plan. You might want to get a beneficiary deed set up at that point. Those are just, anytime that there's a lot of assets that are moving around, it's going to be a good time to at least think about, hey, maybe I do need to come back in and have some work done.
And lastly, in this section, kind of not making some changes, law changes. Obviously, in 2019 or 2020, we had a decent, significant law change. And that would really want to move you to make some changes. And it was the Secure Act, right?
Yes. So whenever the Secure Act came in here this year, that's another one where with trusts, whenever that law changes, you're going to want to come in and make sure that your trust is still set up to where it's going to work with this law change. And if it's not working with the law change, then what we need to do is we need to create an amendment to this trust. So then it is going to work with the Secure Act. And so something here at TuckerAllen that we do that can help with that is that we have a plan called the Legacy Protection Plan. So what that is where every year you're paying us, and then what we're going to do is we're going to review your trust documents and your estate plan for you. And whenever we see issues, then we're going to come back to you and say, hey, here's some stuff that we need to think about doing. And along with that protection program, some of what we do will be free.
And, that's the big thing. I think the drawback many people will have, the hesitation is like, if I spend $1,700 or $1,500, do I have to do that every time that the plan changes or the law changes, or I have a change in children or a divorce? And I think that's what's interesting about the Legacy Protection Program, that is really very affordable, a couple $100, and it includes all kinds of changes and reviews of the documents to ensure that they're meeting your needs. So you're not spending that $1,500 or $1,700 annually or every 2 years or every 3 years. So it really makes sense when you make that large investment. It's a good investment, and there's a nominal moving forward. And that's when you're looking for, I think, one of the things that I thought was very intriguing is when you're looking for an estate plan attorney, find someone that offers that. There aren't many that do that. That Legacy Protection Plan, I think, is huge. And if you want more information about that, check it out on TuckerAllen.com or give them a call, especially if you haven't had your plan changed with the Secure Act or not. So Missy, I'm going to turn to you, and as we continue to roll on, we're getting close at the halfway mark. And if you haven't asked a question yet, go ahead and submit that via the chat box or the Q&A section in the Zoom. We'll make sure to get those questions answered. We have some now. We'll get to those shortly. So Missy, I know we're going to talk about this, and I alluded to it in our TuckerAllen Live segment coming up tomorrow on Facebook Live. But we talk about this is a common error. I'm just as guilty as anyone else, and that is not funding your trust, not only partially, maybe at all, or completely, right?
Sure. So funding is the process of making sure that your assets are controlled by your trust upon your death. So we like to make certain that all of your assets are either owned by the trust outright, or upon your death, they're transferred to your trust automatically, instantaneously upon your death. So I like to think of the trust as a basket, and Teresa called it a pretty document, pretty basket. You spend all this money making it all pretty with all of these instructions about how things are going to be handled. But if your assets aren't put into the basket or fall into the basket automatically upon your death, then your trust doesn't control those assets. And then you're just kind of out of luck. You tried really hard, but you didn't actually follow through and finish out the process of making sure that your assets are controlled by the trust at your death.
A visual came to mind as you were talking about that, and that is, albeit it is an accessory, it's like having a woman's purse, right? And you're carrying it, but there's not a thing in it. You know, and say, oh, that's a really nice purse. What's your wallet look like? No, I don't carry anything in it. I mean, what's the point of carrying the purse if you're not going to use it, right? I guess that's the whole idea of a trust. And that is, but it's a common mistake. And there are law firms, I know from experience, who do estate planning. And the first one I used many years ago, here's your trust, congratulations. No help, no real instructions on funding, and no real telling me why it's important to fund your trust. And so maybe that's a good segment of really, what is the problem if I don't fund it, or if I do partial funding or incomplete funding? Kind of what is the issue with that?
So if an asset isn't funded into your trust, or it's not put into your purse, that means that it's going to have to pass through probate court, and then it'll get put into your purse there. So we spent all this time and effort trying to avoid probate and the costs and time associated with that and the burden upon your family. And here we are right back into probate court again because you didn't put that asset into your trust. So let's take, for example, a car. So you go out and you buy a new car and you're all excited and you go up to the DMV and you get it registered in your name and you pay the sales tax, and you don't think, oh, I've got a trust, my car needs to be transferred on death to my trust. That way, when you pass away, the car automatically falls into your basket or your purse, and the successor trustee can sell the car, or one of the kids can take the car and use it. Without doing that, the car is going to have to go through probate, and then it'll go into the trust from there.
Yeah. So funding is a little bit overwhelming. It's making me sweat right now as I think about my trust. And I know that I would love help. And very similar to the legacy protection plan with Kevin was mentioning that TuckerAllen offers. How can TuckerAllen help for those that are watching, those that either have a plan and haven't funded it, or thinking about a plan but don't want to fund it? How can TuckerAllen help? Can they help?
Sure. So I typically tell my clients that if they haven't done all of their funding within 2 months, they should reach out to us and we can help them. So there is a small fee for it, for us to do all the work of filling out the forms and getting them sent in. I believe it's a $600 fee right now, and we take care of doing that for you if it's too much going on, it's too complicated. If you think that you can handle it yourself, we provide you with lots of instructions on how to go about doing that. But if you're not getting it done within 2 months, you really need to reach out and we'll help you fix it.
Yeah, it can be a daunting task. I can tell you that $600 is cheap compared to what you need to do, as I think about myself and the things that they are. If you had the time, if you could designate the time to do it and you make your way through it, the instructions provided are great. But I would encourage people that are watching, if you've got it and you haven't, or you're worried that maybe you haven't funded it, have a consultation. If you know you haven't funded it, pay the $600 to get it funded. And if you haven't done your estate plan, pay to get your estate plan done. And that transitioned us to Teresa, which I think is one of the common mistakes, is not doing your estate plan soon enough or at all, right?
Yeah, so let's just start with worst case scenario. If you just don't do one, what happens? And when I say you don't do one, you don't have a trust, you don't have a will, you don't have powers of attorney. We kind of touched on what happens if you don't have a power of attorney, or what happens if your doctor doesn't know that you have a power of attorney. So that's kind of the same scenario where if this document just doesn't exist, for the healthcare, the doctor will just look to whatever answers he or she can get at that time to help make the best decision that he could possibly make. And then for for a financial power of attorney, if you don't have that, and if you become incapacitated, and for example, if your kid needs to step in and help you out, then that kid has to go through a guardianship process, and somebody has to be appointed as a guardian or conservator, which can be a very arduous process. You have to go through the court system, get a hearing scheduled. That's just a lot of time, money, effort that could be saved by simply executing a durable power of attorney for a property. So that's kind of the POA side of it if you don't do anything. And then for wills, if you don't have a will, then essentially you're leaving, again, your graces up to the state to figure out what to do. You don't have any control in determining who is the personal representative or the executor appointed to handle any assets that have to go through probate. And you don't have any control about how your assets are going to be divvied up. Kevin mentioned this earlier, and that in Missouri, the default isn't, hey, everything to my spouse. The default is 20,000 to my spouse and split everything else, spouse and kids. And a lot of times that's not what people want. So a will is that basic building block just for you to lay out, hey, here, I've thought about it, and this is who I trust to handle assets through probate court, and who I trust to kind of make sure my distributions are according to what I want. And we kind of talked about this with the trust basket or the purse. The whole purpose of that trust is so that you don't have to deal with probate. So when you have a will, great, you have an instruction sheet that you've given to the probate judge so that you claw back some of that control. But in the ideal world, you have a trust so that things aren't going through probate. But if you don't have a will, you don't have a trust, everything is going through probate, anything that doesn't have a beneficiary set up on it.
And I want to ask you about asset protection planning. And I know there's this 60-month, 5-year thing that's hanging out there. But before you answer that, as you were talking about planning and kind of, doing something or not doing it soon enough, it's much like, and I've used this before in a number of areas of the law, if you file your own tax return, many people in the United States don't use an accountant or CPA to do their taxes. They go online, they pull down the forms, but everybody does it well in advance of April 15th, right? Everyone does. And they do it because they fear that they're going to be audited, but there's such a small chance of being audited. Less than 1% get audited, but yet we spend more time preparing for something that has a very small chance than we do, for example, doing your estate plan. We've been talking about this for 37, 38 weeks, and that is, don't wait until you get sick. Don't wait, especially with this pandemic going on. You have surges across the country. You can't wait. We're in the winter season now. The CDC talks about how there's a higher likelihood of getting sick, strokes, heart attacks, slip and falls, ignoring the pandemic. But yet we're going to play that risk and just hope we don't happen to fall. It would be like waiting till April 15th in the morning and then starting to file or prepare our taxes. No one does that because they've all been ingrained with this notion that we must plan early for our taxes. We must start early. And so that's what we've been trying to get across, especially now. And that is making sure that you plan appropriately. So I want to turn to you real quickly as we get ready to answer the questions that have come in. And that is that asset protection, that 5-year, people talk about it. What is that? Is that something they should be really thinking about?
Yeah, so I think this touches more on the part of the question saying, hey, are you planning soon enough, rather than worst case scenario, I haven't planned at all. Because when we talk about soon enough and asset protection, we're mainly thinking about long-term care. And that's down the road for a lot of us, right? Long-term care, a lot of people come in and they just haven't planned soon enough in terms of, okay, now that long-term care is on the doorstep, what can I do to protect the assets that I have? And then, so that's where that 60-month rule gets brought up in the conversation, the 5-year rule. And that's essentially related with Medicaid. Medicaid, as of now, is kind of the most prominent cover of long-term care. And in order to access Medicaid, in order to be eligible for it, you have to make sure you kind of pass the test of the 5-year look-back rule. And the 5-year look-back rule is saying, hey, have I made any transfers in the last 5 years before applying for Medicaid that would jeopardize me or incur a penalty period that I would have to wait out before I can get long-term care coverage.
Yeah.
And if you plan ahead enough, that's where we talk about asset protection trusts. If you plan ahead enough and you don't wait until less than 5 years, when you have 5 years or more, if you're not even really that worried about long-term care, but you think that it might be a concern, this is the right time to do it, right? This is the right time to set up an asset protection trust along with your revocable basket trust and the will and the powers of attorney, because essentially what an asset protection trust is, anything that you put in here, I think of it as a lockbox. Anything that you put in here is kind of protected, especially if it can run that 5-year clock. So when you apply for Medicaid, and if it's outside of that 5-year look back period, Medicaid's like, oh, we don't see it. That's not your asset for us to judge you on.
Yeah. Let me real quickly, there was a question with someone watching who's leaving here shortly that you wanted an answer. So maybe, hopefully Susan's still on. Missy, I'm just going to toss you this question before we get to the live question round. Susan wants to know that if you could really kind of share the consequence of 80-plus-year-old parents that refuse to put together a will. Specifically, what happens tax-wise or probate-wise if they won't do it. Susan has a great relationship, but just they don't discuss money or end of life like a lot of people. They're afraid to address it, and it's especially with older parents, you don't want to let them think that they're about on death's door. But really, kind of what are the consequences there if it's tax-wise or probate-wise if they just pass without a will?
Sure. So it'll be a messy scenario if they don't want to do anything in advanced planning, but that happens sometimes with elderly people. They're stubborn. So what I typically see happening is that when one spouse dies, any assets that are jointly owned with their spouse will pass entirely to their spouse. So if they co-own their house together and they're both on the deed, then the surviving spouse gets that asset. Anything that was in their individual names, though, that could end up being split between the spouse and any living children. Then we've got other things like bank accounts and life insurance and 401ks that will follow according to the directions on their beneficiary sheets. So if you have spouse down as your beneficiary on your 401k, then the spouse would get all of that money. However, lots of people don't think about those beneficiaries, haven't updated them in 50 years, and it might end up going through probate anyways because whoever they put down, or they didn't put anyone down at all, no longer exists.
I think the best entree, if they haven't already, Susan, especially to kind of enter into this conversation about a will and preparing, is really, for me, healthcare and financial powers of attorney. And it seems to be a less of an approach with someone who was a little bit older and saying, look, hey, with the pandemic, with your age, with your health, let's just make sure we've got those things in order. In the event that something happens, not that you die, that maybe you go into the hospital, I'm going to be prepared to make those conversations or make those decisions for you. That's a very simple first step towards getting a good estate plan in place. Or just, hey, let's have a conversation via Zoom. We don't have to go anywhere. Let's just dial up, let's TuckerAllen, let's have a Zoom conversation about what we can do to protect not only the two of you, but me as well and the rest of the family. I think, Susan, that's a great entree to do it. And really, it's a very difficult conversation. I've had that, difficult time with some family members as well as moving them to that point. Unfortunately, I had one where it was at the very end. We were really pushing them to get it finished and get it resolved. So tough situation, but I think starting for me, with healthcare and durable powers of attorney is a good start. So hopefully that answers your question, Susan. So if you have questions just like that, you can log in, submit a question via the Q&A section or in the chat box. We'll certainly get those to you today. We'll start our Q&A. We have a bunch of them that are here and they'll continue to come in. So Jackie has a question, and I'm going to turn this over to Teresa. It says, you're talking about funding. What about having beneficiaries, TOD or POD, on some assets and trust on others? Does that avoid probate?
So all of that is kind of under the funding umbrella. When we say funding, we mean, hey, if you created a trust, we normally recommend the trust to be POD, the assets to be POD or TOD to the trust, depending on what kind of asset it is. And it really is your call. So for example, a lot of times the distinction between whether we should put it in the trust right away or just setting the trust as a beneficiary, the main distinction is when you put something into the trust, then when you're using that trust or accessing that trust, making decisions, you're wearing your trustee hat while you're dealing with it. Whereas if you set up the trust as the beneficiary, you're still the owner. You individual, or you and your spouse as individuals are still the owner. It just falls into the trust basket after both of you have passed away, or after you have passed away.
So it's a good combination of using everything and including the trust. But Missy, did you want to add something?
Yeah, I want to follow up on that. We actually have several clients who think that they've set up their trust, but they decide to use PODs to an individual instead of to the trust. And that is what we consider to be a mistake. You spend a lot of money and time and effort putting together this really great trust, and then you decide not to use it. Of course you should use it. It's like the empty purse scenario. So we want it to go into the trust because the trust has all these protections in place and all these options. So if the first person you put down is no longer around or is incapacitated, it goes down to this next person here, or it's held in special needs trust for them. So it's so much more flexible than using a transfer on death tool. And you've already set up the trust, so you should try and use it.
Yeah, I mean, just there's so many tools to accomplish what you want, whether it's a house, a farm, or whatever it is. You don't want it to be taken, or a portion of it taken by attorney's fees or whatever it may be, or death tax, the government. There's so many instruments that you can use, but you have to take the first step. That is making the call. Going online. You don't even have to call. At TuckerAllen, you can schedule an appointment online at TuckerAllen.com. So let's go to the next question. Teresa, this was submitted. What constitutes an estate, and what are the differences in wills and trust?
An estate is essentially like an accumulation, the aggregate of all your assets together. And then so when you think about wills and trusts, it's kind of like, okay, what part of my estate is dictated by my will? What part of my estate is dictated by my trust? And what wills dictate is anything that has to go through probate. So that would be your probate estate. And ideally we'd be avoiding that. And like I said earlier, a will is just an instruction sheet to the probate court. So you're providing instructions for anything that is not inside of that trust. Your trust estate is anything that you've put inside of your trust basket, or anything that falls into your trust basket because the trust was the beneficiary on that asset. So that's kind of how those two are differentiated.
All right, Missy, coming right back to you. Joseph asked the following question. My wife and I have a separate trust from 2007 when the estate tax was much lower. Does it make sense to revise that to a joint family type of trust, since the joint tax is roughly 22 million and we are not in danger or approaching that level? And I know that, you know, with the transition into a new administration, we may see a different revision of the estate death tax as well. So maybe you can try to give Joseph some general ideas without really getting very, very specific about what he should do.
Sure. So we see a lot of people coming in with separate trusts like that. They're called A-B trusts. So one for the wife and then one for the children later on. So the downside with those is that in order to protect your money from taxes back in the day, the living spouse lost access and control over some of the deceased spouse's assets. So to make things as easy as possible on your spouse and give them the greatest control over your assets, making a joint trust, or even still having two separate trusts that are more updated and no longer an A-B trust, means that there's the greatest amount of flexibility and the greatest amount of just ease to handle things after one spouse dies. So we wouldn't want your spouse to not be able to access some of the assets that were in your own name because you were trying to shield it from an estate tax limit that you're not approaching right now. We don't know what the future holds, but I would be surprised if it greatly decreased right now, the estate tax planning threshold. As you mentioned, it's 22.4 million or something like that right now for a married couple. So if you're not getting close to that, there's some risk assessment and you can decide if it's better to have flexibility right now, or if it's better to plan for potential decrease in that threshold in the future.
So for Joseph, I get what you're suggesting is it makes it a little bit easier to have a single trust rather than an A-B trust if they're not approaching the 22 million, just from the ease of access to all the assets. So maybe better for Joseph really just to consider it.
Yep, that's exactly.
Okay. Great. All right, let me ask Kevin. We have a living trust that is funded, and we have wills, healthcare directives, and power of attorney in place. They did those last year. They're just looking for an update, I guess, on those situations. Can they update them? Should they be thinking about updating them? What should they be doing?
Sure. So potentially they may want to update some of those things inside of their estate plan. So the Secure Act, like we had talked about just a little bit ago, it's come into effect this year. And if theirs isn't Secure Act compliant, then they might want to get an amendment to get that done. And just kind of listening to what you said there, I think maybe they might want to think about getting a healthcare power of attorney as well, or HIPAA waivers, something like that. But that would be what I can think of off the top of my head here.
Great. Speaking of the Secure Act, Teresa, a question comes in. It says, should my separate and Roth IRAs have my trust as a beneficiary? And that's from Gloria.
So normally we say with your retirement accounts, your spouse should be the primary beneficiary because there's the spousal rollover tax advantages. So when you have a trust, then we say, this is one of the exceptions where you can have your spouse as first and then your trust as that secondary beneficiary.
Yeah. Missy, any advice on, and this is always in the news, especially with cryptocurrency, and its rebound of its valuation, any advice on holding cryptocurrency in irrevocable trust?
Yeah, you can certainly do that, and that's a good, safe way to do it. The key, though, with cryptocurrency is that you have a personal key to your cryptocurrency that only you should have access to, and you need to make absolutely certain that that personal key is passed on to your successor trustee so that person can access it. The problem is if you pass away and you don't give them that personal key, then they cannot get access to your cryptocurrency at all. Even with a court order, the technology is so restrictive right now that even with a court order, no one can get in and get access to your cryptocurrency. So if you don't pass that personal key on, then you're going to end up losing all of that cryptocurrency and not passing that on to your family.
Yeah. Teresa, a quick question came in asking, what is a IRA beneficiary trust?
That's a great question, Scott. I think for that one, to discuss more in detail, they can make a consultation with us and we can talk more in detail because I definitely want to get more information on that situation.
Yeah, and it is always danger to try to answer some questions that really kind of walk the line about getting some legal advice. And so we suggest just schedule something via Zoom, phone, or in person where appropriate and where you feel safe. So give us a call. So Teresa, then what are the best options for selecting your successor trustee? Family member, friend, or paid third party?
Yeah, so Missy touched on this earlier, but it really just depends on the circumstances of each family. This is a very common question that we get. And oftentimes I tell clients, you know your family better than I do. If everyone's kind of harmonious and you have a child that is responsible and trustworthy, then it totally makes sense to have a family member be a successor trustee. Yeah. Or if most of your kids are minors, then sometimes, and a lot of other family members live really far away, then sometimes it makes sense for a friend to be a successor trustee. So it really depends on the circumstances, and I think that's something you definitely want to talk to your attorney about.
All right, Kevin, what are the charges to change a personal representative? And this maybe spill over even to, we talked about the legacy protection plan, but maybe you can talk a little bit about that.
Sure. So here, if we're going to change a personal representative, it will force us to create a new document for you. And the charge for that, for a single new document here at TuckerAllen, is going to be $350. So that would be what the charge is. If you did have legacy protection program, though, a change for something like a personal representative, that would be free.
So free, I like the word free, and I think everybody else would too. And that's one of the keys to that legacy protection plan. When you get an estate plan done there, you certainly want to sign up for that and enjoy the free changes annually or biannually. So let me go to, let's see, Teresa, how is capacity measured? And that's always a question, like incapacity, capacity, what should they be looking for? How does that get measured?
So it's a little gray. If a client comes in and I have some hesitation about how much they understand about the situation, I normally say, hey, let's just get a doctor's note just to be safe. And I just get a doctor's note saying this person has the capacity to understand and to create legal documents. And then with that, I get that assurance and I can move forward. In terms of capacity in creating estate planning documents, I think the general criteria are they of sound mind? Do they understand what the documents they're creating actually are? Like, do they understand the contents and the purpose of creating these documents? And do they know what they're signing? So I think those are kind of the general criteria to assess capacity. And if that is kind of questionable, we normally request a doctor's note to go along with that.
Great. All right, Missy, this question came in. a little bit long. It says, can a sibling who lives out of state easily serve as attorney in fact or successor trustee for a deceased sibling's estate, or should someone local be appointed?
So anyone can serve as personal representative or successor trustee or anything along those lines. With a personal representative, it's going to be going through probate court, and the probate court is going to require a local agent to be appointed to like accept mail on their behalf and stuff like that. And that's a very informal position. There's not too much to do with it, but they're going to ask that. So that's just one extra piece of paper and one extra name that has to be involved in the process. But it's completely feasible to name someone out of state, and that happens a lot.
Yeah. All right, Kevin, coming back to you. What percentage of people put limits on how their estate is distributed? They ask, a friend told them that they only allowed their heirs to receive $3,000 a month until it's exhausted. How often do you see that?
I would, to put a percentage on something like that would be difficult, but I would say that it's fairly common that people have some sort of limit that they want to put on how their estate is distributed. A common one that we see, what might be, they would say, I want to give my beneficiaries 1/3 of their inheritance at this time, 1/3 of their inheritance at this further time, and then the remainder of their inheritance at another time. A couple of things just to think about while that's a good idea, especially if there's a good reason for it. Just practically speaking, especially like the idea of people getting $3,000 a month until it's exhausted. What that's going to do is just practically, it's going to cause somebody to work pretty hard to be able to get all this done. There's going to be a trustee out there that's working. They're going to be taking a charge too from the trust, because what they're doing isn't easy. It's a real job that they're completing each month for you, or every 5 years, or if you're, let's say that you had the 1/3, 1/3, 1/3 set up and you did 25, 30, and 35. So that's 10 years now that we have a trustee that's going to be taking some payment from that trust over the 10-year period. Just another quick thing to think about in a situation like that. It can make things a little more difficult. It can make this job a little bit longer. That might be a good time to think about having a successor trustee. That would be a corporate trustee that could kind of handle some of that a little bit better maybe than just your friend could.
Yep. All right, Missy says, my mom is in assisted living. Should she outlive her money? When is the proper time to initiate Medicare services? She's in good health. She has around 6 years of cash on hand for her care. We really are not looking to save any money for her children. So really, I guess the question is, when is the proper time to initiate Medicaid services?
Okay, so you said Medicare first. I want to clarify.
Yeah, I'm sorry, Medicaid. Sorry.
Okay, Medicaid requires you to have less than $5,000 worth of assets to your name in the state of Missouri. There are some exceptions if you've got a spouse, then how much money they can have under their own umbrella. But generally speaking, it sounds like we're not worried about anyone else other than mom here. So to even apply, she needs to have about $5,000 of assets or below. So if she has to run through her assets until that point, then we would want to make certain that it's right around the $5,000 level. There is some planning that we can do if you were concerned about preserving some things with like a private pay and gifts and stuff like that to help run that money down earlier. But if you're not concerned about that, then the $5,000 is what you need to be thinking about. Do note though that that number changes frequently. So if we're looking at years in the future, you just got to keep an eye on that number. It will probably change.
Yep. All right, let me go to Teresa. How often should a trust be amended?
So again, this is circumstantial, but we normally recommend visit it at least every year, every couple of years. If you are under our legacy protection plan, that's a great way to stay on top of it because we're monitoring that for you. But other than kind of that regular maintenance of your estate plan, anytime there's a major life change, we talked about marriage, divorce, having kids, grandkids, those are all certain points that should trigger you to think about revisiting your plans and maybe making an amendment to your trust.
And just coming right back to you, Teresa, since on the subject of a trust, and Jackie asks, besides avoiding probate and the organization of a trust and having all the info in one place, are there any other values of a trust that we haven't mentioned, like any benefits to having the trust itself?
I think when we talk about the funding process, this was tangentially touched on earlier as well. If you have the trust as the beneficiary or everything in some way tied to the trust, that kind of gives you a really comprehensive peace of mind, because then you don't have to worry about monitoring all your different types of assets and whether beneficiaries need to be updated, because if they do, if you have somebody as a beneficiary on everything and something happens to that person, then you have to go and change everything. Whereas if you have just the trust, that gives you more of that longevity of that peace of mind too.
Yeah, and tax consequences, following the, you know, the order in which you want things to happen, who gets what, when they get what. I think it really is kind of the end of your life plan by, you know, hey, this is my legacy. This is how I want it to go. You know, and probate is a huge thing. We don't want to pay more lawyers after, you know, your death. You don't want to pay taxes on top of that. So I think that's a huge benefit. And I think there are just a number of different vehicles that you can use. Whether it's life insurance and irrevocable trusts. It's just the wonderful thing, I think, when I listen to you three, is that, you know, in estate planning, there's just so many different ways that you can plan that are unique. Particularly, Jackie, you may want to have that conversation. You may have put together a really unique plan that just really exposes what's better than just avoiding probate. So I encourage not only Jackie, but everyone watching to reach out to the attorneys at TuckerAllen. So thank the three of you for joining us. It's kind of reached to the end of our virtual town hall today. I look forward to seeing everyone tomorrow on TuckerAllen Live, 15 minutes. We're going to talk a little bit more about funding your trust, about what happens, the process, what you should be looking for, what you can do, what you should do, and who you should contact. So go ahead, follow us on social media, log on right now, go ahead and just plan for tomorrow, 1 o'clock, TuckerAllen Live, Facebook, 15 minutes. If we didn't get to your questions, we'll certainly try to answer those as well during the Facebook Live segment. You can also log in then and ask questions live. We'll get you some answers as we're joined tomorrow and every Friday. Look for our next virtual town hall information by looking at TuckerAllen.com. You can get a lot of information about the panel today, about the services they offer as well. You can give them a call at 866-335-3375. And consultations are available via Zoom, just like this, via FaceTime, via telephone, or in person where appropriate, considering your health and safety. Don't wait. Go ahead and take action, just like we talked about today, to avoid those mistakes. So thanks for joining. Until next time, have a good rest of the week.